Hello, everybody. Thank you so much for joining us today in the Art of Estate Planning Facebook Live for our much anticipated topic. My client died with a testamentary trust in their will, and what do I do now? So I am joined by special guest Carrie Payne, also known as Catty Abernathy, the original cat lady lawyer. So welcome, Carrie.
Hi, how are you, everyone? Nice to be given the opportunity to present in front of everyone.
And Carrie, I'm very grateful that you have agreed to join me today and share your insights. Carrie and I go back a long time to the View legal days, so it is nice to be getting the dream team back together because we worked super closely on the online platform for several years together.
Yes, I was saying to Tara earlier, I've got some Tara stories, some which I'll share, some which I won't. But certainly I remember working with Tara when she was a city yoga queen and not a beach bum. So I think
a much more stressed out lawyer too back in those days.
Yes. I think I remember one of the defining moments in our working relationship was I said, "Are you okay?" I remember that date, and I remember thinking that's when things turned for us, and we weren't just, mentor and mentee. I think it was really a sign that we'd progressed past that. So,
yes, colleagues and good friends. So, Carrie, we've both moved on to bigger and better things since the View legal days. Tell me, what are you doing now?
Yeah, so I mean, I've had a bit of a unique experience for some. I've always worked in small businesses and only ever in estates and structuring, including business succession. I started off with Tara and her team, and then for the last 3.5 years, I've been working over at Business Depot in their legal team there, and sort of heading the estates team there. And it's been a really unique experience because I've been subjected to. We shouldn't say subjected to, that makes it sound negative. I've been really fortunate to be involved in a multidisciplinary team and working alongside accountants. And that's where I think a lot of the knowledge that I've got today comes from, mostly working alongside them and seeing the practical stuff of when you're administering testamentary trusts. I've decided I wanted to do law a bit differently in the famous words of Lucy Dickens, and I'm now actually contracting back to Business Depot through my own law firm, and that's kind of where my passion is going to be, is stepping in and under a law firm's branding, delivering specialist estate planning products and solutions to their clients. In a way that still looks like it's them. So from a client perspective, it still seems like it's that law firm. And so that's where lawyer kind of came from. I think that it's still very early in its days with lawyer. I'm still getting all of the bits of paper together. So forgive my rudimentary website, but it's exciting times, definitely.
Congratulations on taking that leap, Carrie. It is a huge step to move out of the certainty of being an employee lawyer into running your own show, but you're totally ready for it, and I know it's going to be a success. So let's get into the technical topic. I know that's what you're all here for, and thank you for everyone saying hi, letting us know that you're there, and who made time in your day to join us. We're very, very grateful. And this is a funny little topic because we all talk about testamentary trusts so much, and we are part of this new wave of advisors who believe in the power and importance of testamentary trusts. But if you're feeling a little bit sheepish about not having had practical experience about actually setting one up, or if you're not totally confident in the steps of getting one live, I don't think you're alone, because I've been hearing from plenty of people in the group that they are feeling this experience. And I think it is really just a practical reflection of the fact that while we might be setting up clients with testamentary trusts, not many of them are dying with testamentary trusts yet. We haven't had that wave of popularity come through in the estate administration phase yet. I think, people who made their wills in the 80s and the 90s, even the early 2000s, there was not this take up of testamentary trusts as we are seeing in recent years. So you're not alone. In fact, I've only ever done a handful of them, and that's why I brought Carrie in, because I'm not an estate administration lawyer. I look at this through the lens of the tax position and the technical trust position and my experience with setting up discretionary trusts, but I've hardly ever done them as well. So Carrie has, and that's why we thought we would bring her in. Now, as usual, you are so welcome to put your comments, questions, feedback in the comments section. We'll try to answer those at a sensible juncture as they relate, and we'll also have time at the end to go through everyone's questions as well. And I will have a flyer available at the end as well for you with the steps, so that you've got an easy cheat sheet on how to actually set up a testamentary trust that you can refer back to. Now, that's probably enough for me. What I might do is hand over to Carrie so she can get us into the juicy content. Carrie, all yours.
Thanks, Tara. I'm aware today that we've actually got a really wide range of audience members. So everybody from lawyers that do and don't do estate administration, all the way up to, you know, financial planners that do and don't necessarily yet do estate planning or are involved in the administration aspect. I've sort of tried to tailor it as a result on that really wide range of members, but certainly today is not designed to be sort of narrowed down into one area. If you've got any questions, I'm always available to have a chat. I sort of say that I don't answer my phone if I'm sleeping dead or in the shower, and even then I've been known to answer it. In terms of the actual sort of process, I thought I would keep it simple and limit it down to these sort of 4 concepts. Number 1, identifying what is the trust deed, transferring assets into the testamentary trust, what registrations you will need, and then post-establishment considerations. And these have been designed based on some feedback that I got from people both directly through the comments on the post I put, and also through some private messaging. Now, I'm actually really excited to talk about it because I get to say a lot today, it depends, which is the lawyer's favourite token statement. Because what constitutes the trust deed for a trust really depends on a few different factors. Number 1, whether there's a will, whether there's a codicil, what provisions in relevant law apply or don't apply, and then whether there's been anything that amends those through court orders or alternatively. But to make it sort of simple so we can break it down into looking at what terms apply, I've broken it down into what we know as testamentary discretionary trusts, meaning those comprehensive trust deeds that we build into our wills, okay, that have a discretionary nature in how assets can be applied. And then I've kind of got this other group, and it'll be clear what I mean by other. I won't labour the difference too much. I know that Tara has got some IP on the differences between the two, and she can provide you that link to that. I think it was a presentation. Forgive me if I'm wrong, Tara. But yeah, I won't go into too much detail on that, but more so looking at how we identify those terms. So if we start with the testamentary discretionary trust, so the trusts that we build into our wills that have really comprehensive terms, the trust deed is effectively a combination of what I call these couple of things below here. So it's definitely what's written in the will itself, okay? So what are the terms as set out in that document? Number 2 is looking at whether there's any codicils, okay, and it's something that's commonly forgotten, but a codicil is effectively like a deed of variation for a trust, okay? It is varying the terms of that trust through that document. I've put down here grant of probate, and the reason I've put that in is that once you hand over the will and the codicil to the Supreme Court, what operates as the trust deed then is the grant of probate. And I had to talk to a junior about this recently. A grant of probate isn't just the bit of paper, it's the will annexed as well. So when we're talking about that, you can't just hand over that front page from the Supreme Court. You've got to hand over the copy with all the terms in it as well. One thing I really did want to talk about here at the bottom here is the concept of the Trusts Act being relevant. And in preparation, I actually went and double-checked 4 out of the states in Australia to make sure that I wasn't talking out of my nose. In terms of the Trusts Act, there are certain provisions in the Act in most states that say this area of law applies unless it's negatived. So one of the examples I always give is the requirement for the trustee to have the performance of the trust investments reviewed each year. So again, that's definitely a requirement in Queensland, New South Wales, Victoria and South Australia. I think I checked all this morning. And they all have a roundabout way of saying that unless it's negative in the trust deed, that must apply. So being aware that the powers themselves aren't just what's written in the hard documents themselves, there's some other relevant legislation that applies as well. Okay. If we jump over to the next one here, I've got this other basket. And again, without labouring the point too much, testamentary trusts are a broad term for any sort of trust that is established to hold benefits of a deceased person. And that can include the discretionary trust, which we talked about, but it can also include things like bare trusts. So for example, I leave, actually I'll use Tara because everybody knows I don't have children, I have cats. Tara leaves her baby $100,000 and he's not 18 yet, and the will says that when he turns 18 he gets those assets. So the will doesn't have any other terms in it other than the gift goes to him and it's signed at the bottom, those sorts of things. It doesn't have that really comprehensive set of powers. That is still a testamentary trust. It's just not the testamentary discretionary trust that we all refer to when talking about the planning sort of landscape. So if there is a will, there'll be whatever powers there are in the will, and what powers there are already do tend to vary on, again, each practitioner, how they draft a document. I've got a summary document that says what powers should be in every will based on too many hours I spent at the library last year and some advice from Tim Whitney. So I'm happy to share that IP if anybody wants it, feel free to reach out. But then also, again, similar to anything, you can have a codicil. I've put down here grant of administration, and the reason I've put administration and not probate is that you may be operating a testamentary trust if there is no will. Okay, so if you're holding the assets for the benefit of children under the rules of intestacy, and that's kind of why I've got the Succession Act over here as well, because sometimes the terms of the trust, particularly who can benefit, so the beneficiaries, aren't necessarily written down in this sort of document. Now, again, I've put the Trusts Act here because, again, there's often these additional powers that unless they're negative in the document, then we're going to have to look at that and see that they apply. And the less powers you tend to have in your wills, so the less comprehensive the wills tend to be, the more likely you are going to have an issue where something like that review investments requirement does apply. Now, I've also put down here an estate proceeds trust or a superannuation proceeds trust. And the reason I've kind of put this here is that sometimes people don't walk into an estate administration from the beginning. More often than not, people come to another lawyer because they're frustrated with what's already happened. And sometimes a part of the work that has already been done has been setting up an estate proceeds trust. I won't talk about them again too much on the basis that I know that Tara has a lot of information available about those sorts of structures, but being aware that there might be this overriding document that has in it extra powers that's not the will and isn't the codicil. Tara, I just thought I might stop and see whether there's any questions about those two concepts first. I've got the beauty of having a very small screen and a cat fighting with a ribbon on my right, so I can't see if there's any questions that have come up.
No questions other than people just saying hello. I might just mention, though, it's interesting that, you know, the grant is the trust deed, because compare that to like a discretionary trust deed. The grant with the will annexed could contain quite a lot of private and confidential information about people and assets and affairs unrelated to the testamentary trust. Like, I mean, sometimes it's just like boring and not really, but when you think about it, like there's actually quite a lot of private information that can be included in a will. And so sometimes in the past, I've used what I've called a consolidated trust deed for the testamentary trust, which is to kind of take the guts out of the will, which comprise the testamentary trust terms, and put like a nice testamentary trust cover page in and try and dress it up to look a bit more like a discretionary trust deed would, rather than the grant and the will. And I just wanted to mention this because if you've got a client who is a bit worried about this or confused, like that could be an add-on that you might like to give them to accompany the process. Now, you would have to be careful about who you use that consolidated trust deed with. Like obviously the titles office and the tax office may not accept it. It's not the true deed. Same perhaps with a bank account, but maybe with a bank account. But I just find sometimes that can be a little bit useful to use as the working copy of the terms. And if there are any variations, you kind of just build that into the process as well. So just thought I'd mention that as an option, particularly if the will does contain private information.
Yeah, no, that's great, Tara. That's actually very, very good. And that you're right, that is a really practical tool to give to clients, particularly when there's sort of iterations. So if there's one or two codicils, having sort of just one centralised document just makes things so much easier from the client's perspective. So,
yeah.
The next thing I want to talk about is registrations. So one of the big questions was, what do I have to do? You know, what do I have to register? And again, I get to say that fabulous phrase, it depends, because similar to a discretionary trust, so a normal family trust, what you need to register the trust for depends largely on the assets inside the trust and the activities that the trust is undertaking. What's really consistent, though, is that you need a TFN. Okay, so your tax file number. So you'll get a tax file number for the deceased estate and you'll get a tax file number for the testamentary trust. Just being aware that if it is a sort of a bare or a fixed trust, because it's the executors holding the assets on trust until the children turn 18, then often the TFN is the same as it is for the estate. So not always do you have to apply for a separate TFN. This is just usually when you're using this whole separate structure. Applying for a TFN, generally speaking, I give to the accounting team because they can actually enter in details, including registering them as the agent, so the information then gets sent to them. I'm really passionate about just doing the legal piece, so I take a really hands-off approach to that sort of stuff and let the accounting team support that process. However, I do know that there's some people out there that really do want to take a hands-on approach because the client likes that. It's actually really easy to get a TFN for a trust. There's a website that's set up by the government that you can go in and you can put in the details from there. The only complications I find is that there's some sort of choices about putting down what sort of trust it is and what the activities of the trust are. So those are something, again, that can vary depending on what the trust is doing. I'm happy to walk anybody through that wants me to walk them through that process for the first time. But certainly just being aware that you have to get a TFN for a testamentary discretionary trust. It's not that difficult, but it can be easier to hand that task over to the accounting team.
And Carrie, I'll just mention for the accountants on the call, there's no testamentary trust option when you go to the tax file number application and the drop down. And I've had a few people go, which option do I choose? So you go to the core.
I've got it up here, Tara, if you want. I can share the screen.
Yeah, fab. So yeah, you basically so Simran, it's the same a tax file number for any trust. If you're setting up a new family trust, a unit trust, SMSF, it's the exact same process of applying for a tax file number, and you go to the core nature of the trust. So most of the testamentary trusts that we're preparing will be a discretionary trust, but if it's, as Carrie was saying, that bare trust for minors, then that's a fixed trust. Or if you've got randomly a unit testamentary trust or a fixed testamentary trust with extensive terms, it's a fixed trust. So you have to sort of when you're applying for the tax file number, forget that it's a testamentary trust and just go to what type of trust is this really? And then it's pretty much the same as if it was a, oh, sorry, Carrie, let me bump that up into the screen.
No,
then it's
you're
pretty much
fine.
Same as if it's a, any kind of, inter vivos trust.
Yeah, and they've got, as you said, Tara, they've got here, if, for example, it's a fixed trust, like it's a bare trust that is on the benefit of, one child or a couple of children in particular, you pick your fixed trust option. If it's a testamentary discretionary trust, I would pick the investment option here.
Yeah.
In terms of the next part over, this is the part I always find the most confusing. We're going to put yes, and we're going to put no. And then here's the part where you can put your tax agent number. So just being really aware that, again, that can make it easier if the accounting team is doing that. And I'm just going to put in here, I put in some examples here. The Atticus Payne, that's my cat's name. Testamentary trust. This part is where it gets difficult talking about the main business activity. And what I tend to find, if you put just testamentary trust in here, and then actually go down here to the category, that will actually pull up some categories that are immediately applicable. And I will generally pick this one called a personal trust, okay? So that sort of is just the two main things that I find can make it a little bit more difficult, is knowing what type of trust to select and then what the main business activity is of the trust. I'm happy to have a discussion with any accountants that might not agree with me.
Yeah, so I think, when you get to this step, you just go back to core principles about the trust and the nature. It's nothing, it seems scary, but it's actually nothing extra.
Yeah, excellent. Sorry about that little detour, guys. So yeah, it's just the online business register, or the Australian business register. You can go and get a TFN. You can also get an ABN through there, and whether you need an ABN or to register for GST depends again on the activities of the trust. One of my favourite things is always having the fight with the bank about whether there's an ABN for the trust. Oh, it must have an ABN. No, it doesn't have to have an ABN. An ABN is only relevant when you're running a business. So generally speaking, again, what to do with these two, I would always consult with your accounting team, because they're the ones that it's going to affect on a day-to-day basis. It's something you should be aware of, so that you should be telling your clients there will be these extra registrations that are needed, and I can do that for you if you wish, but also it may be something the accounting team wants to take on.
Carrie, I just mentioned the accounting team will have the ongoing management of this entity anyway, so I think the sooner you can collaborate and get them involved in the setup, the smarter that is, because you're going to hand it over to them anyway. You might as well get them to do it properly.
Yeah, absolutely. I probably have come more towards that way, having worked alongside accountants for the past 3.5 years. They're infinitely more knowledgeable about this stuff than lawyers generally are. And it does look better from a client perspective as well, to be working together for the same outcome, which is make the least white noise possible for these people that are obviously in a really not great time, because that's what estate administration is.
Sorry, I'll just say thanks to Trish for also noting that the original will is retained when you apply for your grant of probate. So that's, you've got to inform clients that the new original trust deed is actually the original grant of probate.
Yeah, absolutely. Just with other registrations, again, it really depends on what the testamentary trust is going to be doing and what the sort of terminology is inside that. I've had testamentary trusts inherit things that require them to have liquor licenses, and sometimes they're setting up a charitable entity inside the will. So there's charitable registrations that need to be done both on a national and a state level. So again, your accounting team is generally the best to talk through that with and have a collaborative approach for the clients to work out what do you need to do and who's going to take leadership on that point. This is an actual photo of me earlier this year trying to open a bank account with a trust. So I generally find this is the most frustrating aspect of trusts, particularly for testamentary trusts, because when we get down to sort of trustee level. It's not generally just one person. I physically stood in Westpac last month, no, the month before, for 2 hours trying to get a bank account open. And because my brother, who's the co-trustee, was not physically present in the same branch, they were trying to tell me that I couldn't open an account. So when it comes to opening bank accounts, just being aware that each institution has its own rules. And generally speaking, your experience is going to be based on the person that you're dealing with at the particular time. And as I had to enlighten my father last night, yes, the law might say that you can open a bank account, but they're a third-party institution and they can just refuse to actually do business with you. So I have some really good contacts now as a result of that experience through NAB. So if anybody is having issues with opening bank accounts, let me know and I can pass those contact details on. NAB don't require you to, both of you to be in the office at the same time. They now have an online verification process thanks to COVID. So that sort of gives that a little bit nicer experience there. In terms of what's happened here, I know it used to be a lot easier, and then the Royal Commission happened. There was some legislation brought in, and then I think that some people got in trouble. So then 12 months after that happened, things started to change. So that might be why we're sort of only seeing some difficulties maybe in the last 12 months with that because of those changes. Anyone, any questions?
I suppose, Carrie, if you've got a fair amount of debt in the estate or borrowings that need to be managed, and there is, say, the financial advisor working with the client to help manage that, you would hope that having a relationship manager at the bank going through that process, that getting a bank account for the testamentary trust, particularly if it's assuming any debt, would simplify that process. So again, maybe this isn't, I think the main message here is that this is an area where collaboration is really important between our multiple disciplines, and it's not just a job for the lawyers or just a job for the accountants or the financial advisors.
Yeah, I mean, I think, and again, people have different approaches to it. You have people that are really hands-on and really hands-off. I had a situation last year where I physically went and stood in a bank account in a bank branch with a client until they could help us with her query to open a bank account for a testamentary trust. So I think that, yes, you're absolutely right, Tara. It's all about collaboration and assigning who's going to do what to help the client. I did just want to point out too, we'll be talking later about equalisation strategies. A trust can have more than one bank account, okay? So being aware that, you can have one with NAB, one with Westpac, one with CBA, those sorts of things. So don't sort of be tied to this concept that a trust is just one account.
Oh, great. Yeah, that's a really good point, Carrie.
Yeah. So I think that probably flows on nicely into my point about what actually goes into the testamentary trust. And I've separated out the considerations based on things that are actually written into the will that affect what goes into the testamentary trust, and issues or concepts outside of the will that may be applied and may affect what goes in. So the first one, I know it sounds really strange, but what does the will actually say? Does it say that the residue goes into there, and what is the residue defined as? Or is it a specific gift? Okay, so having a look and seeing what does will say goes into the testamentary trust, and again looking at if it says residuary estate with capital R, capital E, and it's a defined term, going and having a look at those terms. We need to consider the effect of specific gifts as well. So sometimes if something happens to specific gifts and then things need to come out of the residuary to accommodate for a specific gift that for some reason didn't go ahead. So being aware that that affects that, and also then whether there's inefficient estate assets generally, looking at how everything is apportioned as a result. The debt one is something that is really interesting to me because I was going to put it outside the will, but then I think it's actually inside the will, because your wills can say whether debt that's associated with an asset can be assigned to the testamentary trust, or it can be assigned to the beneficiary that takes the asset or paid by the testamentary trust. So what I'm sort of getting at here is that if there's a specific gift of a property into a testamentary trust and that property's got 100K worth of debt on it, who pays the 100K really depends on what the provisions of the will say about assigning debt. And most of the time, if the will's a reasonably drafted will, it will either have a broad clause saying the executor has a bit of discretion about debt, or if there's some specific planning reason for doing it, there will be a specific instruction about that particular asset and debt. The last one I want to talk about is conditions precedent. I actually learnt this the hard way. Most institutions, when you're trying to put assets inside a testamentary trust, will, particularly things like the titles office, will come back to you and say, hey, this condition precedent, has it occurred? And you'll have to fill out some sort of statutory declaration or something similar saying, yes, that has occurred. So, for example, in most wills, people will say, you know, if my partner doesn't survive me, this is what happens. So you'll actually have to physically prove, you know, the condition precedent that my partner has not survived me has happened. That here's her death certificate kind of thing. It's right to go into the testamentary trust. And we had that exact situation. I don't know if Tara has the painful memory of it, but many years ago now, probably about 5, where we sent everything into the titles office and it had, subject to this thing happening, everything went inside the testamentary trust. So just being aware of conditions precedent and making sure that those have been fulfilled, and if not, knowing that how that affects what ends up in the testamentary trust. Things outside the will. So there's some concepts outside the will again. So appropriation, if someone does some shuffling around of assets to, get things into different hands. So for those of us online that don't do estate administration and don't have a lot of detail around appropriation, effectively if you've got the ability to do it, and most states have the legislated ability to do it, if someone is entitled to half of the estate and the other person the other half, you don't have to sort of divide a house down the middle, if that makes sense, and everybody gets 50-50. One person can take 100% of the house and the other person gets their 50% share through other assets. So if that's the case and you've got this person in testamentary trust number 1 getting 50% and this person in testamentary trust number 2 getting 50%, if there's an appropriation, what actually goes inside those two trusts depends on the terms of that. Want to talk quickly about estate challenges and alternative agreements and make it really clear that while I do a little bit of estate administration, I do all the fun, pretty front-end estate administration. I don't do any of the nasty, we don't like each other, we want to fight about things, estate administration. So just being aware that when there are challenges to the estate and there are alternative agreements made outside what the will says to accommodate things like that, that can change what ends up inside that trust. And I've also re-put debt down here again. And the reason I put it down here is that, you can have this really great idea about what you want to do with the debt from a will perspective, but then the person that actually is financing the debt can feel very differently about that as well. So I've got a situation at the moment where property was held as tenants in common, partner passed away, but the mortgage was joint. And so, she's sort of trying to do an appropriation to figure that out, and it's basically all what the financier will let them do. So I think that when we talk about debt, yes, there's strategies within the will and concepts there about how that can be managed, but being aware that things outside the will, such as the financier that's providing the debt facility, that may change how that goes. Anybody got any questions? I've realised that's a lot of information in a really short time. No?
I can't see any questions coming through at the moment, Carrie.
Beautiful, beautiful. In terms of making those things happen, then once you've worked out, okay, well, I've gone through all these things that might change what goes into the trust, it's then just a matter of identifying each of those assets that end up inside the trust and doing the relevant transfer procedure. So if it's shares in a company, okay, a private company, you'll do your ASIC documents. If it's shares in a listed company, you'll go through usually your share register. If it's property, you'll go through the titles office, those sorts of things. In terms of the key thing that's really important here is to document everything. So, when it comes down to making decisions as trustee and as executor of the estate, you need to be recording and writing what you've done so that it can be clear. And I think, Tara, you touched on that a little bit yesterday. Each sort of will have its own requirements about how decisions can be made. Even if it says it can be made orally, I would always put it in writing anyway. Okay. Now, the last thing I want to talk about is post-estate or post-establishment considerations. So I sort of grouped these together based on a few questions that people had asked, because I appreciate that some of these might have been handled in the planning end, but the reality is that you might get these problems. Again, I'm going to say it depends, because what the issues are depends on what the Testamentary Trust is doing. But what I've tried to do is I've picked sort of 4 ones here that came up based on the questions and that I think are probably really common. The first one here is equalisation strategies. So someone sort of said, how do you manage that? And I think that, again, this is something that really requires a collaborative approach from the accounting team, because these are the people that will have the ongoing management of the trust from a financial perspective. And I have known that people often hold things, sort of they divide the financials up kind of in whatever portion the trust is notionally split into. Some people manage it through separate bank accounts. So I've got 2 bank accounts. One I put aside for my niece as a part of a discretionary trust, and the other one is just sort of my fund money. So I think that another way to do that is through separate bank accounts. What I would say in talking about those 2 concepts is be really careful what you're putting in writing that makes it clear that someone has like a kind of or a pseudo fixed interest. Generally speaking, while a decision hasn't been exercised to distribute trust assets in a certain way until the decision is actually made sort of prior to 30 June, I always just think if I were the family lawyer from the other side and I saw that there are financials that said this person has 50% and this person has 50%, I'd probably find that pretty interesting. In terms of actually equalising out later on as well, if people want to go their separate ways, I'm not sure if Tim Hall's on this call, but we did this recently with him where effectively there are ways that you can equalise between existing family structures in the Testamentary Trust by doing a bit of magic of numbers, and then children can kind of take one and the other, and they're not stuck in the same structure together. Transfer of control. Initially, again, it's just a matter of preparing documents and lodging those with the relevant parties. The subsequent sort of appointment of people that are controllers generally depend on, again, what the mechanism was to get the next level down. And so what I mean by that, what happened to the first trustee that meant that we're now relying on the next level down. Again, your deed will generally say what are trigger events to someone being removed as a trustee, and then what happens to that person. Again, really, really important that we focus on recording everything that we do and making sure that it's all in accordance with the terms of the trust deed.
Carrie, I'll just mention as well, great idea to get the trustees and appointors and any other control role, the people who are appointed to those roles, to review their estate planning with respect to the trust as well. So once they take on the responsibility, perfect juncture for them to review their own estate plan.
Yeah, absolutely, because a lot of people don't realise that that if there's no backup to the person that you've appointed, most of the trustees will have a default mechanism that says it's that person's estate, so executor or financial controller of some sort. So you're absolutely right, Tara. When you assume those roles, that's a really good trigger point to getting your own estate plan looked at.
Yeah, because that could go really wrong, right? Like if mum and dad, baby boomer mum and dad have really decided to set up testamentary trusts for their adult children, and they have tried to keep them bloodline without the daughter and sons-in-law, and then like child A dies and their spouse comes in, it kind of undoes the planning that the parents did. So, it's not always the legal personal representative who's the right default successor in a testamentary trust.
Yep, absolutely. There was a question about disclaiming interests, and I got really excited and did up a slide on it, and I thought I won't bore everybody to death on it. There's actually a really great case, Ramsden. It's FCT versus Ramsden. Ramsden. It's a 2005 case, and it's recently been confirmed. There was a case literally in, I think, 2 weeks ago, the tax bulletin that confirmed that. So it sort of steps out there really nice and clearly about what they consider is an effective disclaimer. If anybody wants the citation, give me a shout and I'm happy to give you that.
And there's different rules for disclaiming under a will versus disclaiming tax entitlements, right? Like you can't just disclaim a part gift under a will. You have to disclaim everything, and then overlaying that with the rules around the tax timing too. So we could do a whole live just on disclaimers, I think.
Yeah, absolutely. And you're totally right. It's different to disclaim just an estate interest, so an asset that was left to you in a will, versus disclaiming an interest in a trust. And then again, as I said, overlying the tax perspective. So I think that, that actually would be a really great idea. We probably should do a whole seminar on that. But there, as I said, there is a really great case where they stepped through it because it went through, I think, 3 different decisions to get to the appellate court. And it kind of steps through that there. Interestingly, I always found was that, generally speaking, you can make disclaimers retrospectively, provided that you do it within a reasonable time of actually finding out that you've got the interest in the first place. Okay.
Sorry, we have just had a request for the citation, so if you can dig that up at some point.
No worries.
That would be much appreciated.
I'll post it in the group after this. How does that sound?
Oh, amazing. Thank you.
No, and I'll also post the website for the TFN registration, because I got so frustrated because it was really awkward to find for a while there. It's now a favourite on my bar, so I'll share those 2 after this. The last thing I want to talk about here is when to wind up. And again, I think this is really a decision that gets made based on balancing up a few different things. So I think that, when the negatives start to outweigh the positives is kind of when you do it. So I've sort of put in the positive baskets: asset protection, tax planning, this sort of generational vehicle to provide wealth to people. And also, the fact that by keeping it in the trust, there are no transaction costs of it just sitting there. As opposed to taking it out, there, generally speaking, can be some transaction costs. The negatives are generally when you're looking at the administrative costs and burden and the complexity that having a trust structure rather than individual names provides. And I also put here this concept of people not agreeing, whether it be at the trustee level or whether it be beneficiaries that are just causing a nightmare and exhausting the trustees to the point where they're like, well, the reason this was set up has not actually come out to pass, and we think it's probably in everybody's best interest to wind the structure up. In terms of the cost perspective, I know that Tara has sort of a working number that she uses for whether a trust is sort of worth it or not. And I think she'll say the only sort of caveat on that is that worth it is very subjective, because, I think Tara's, is it $500,000 is the number that you usually use?
Yeah, of like assets that will be available for investment. And there's not a lot of science for that. I actually think like the financial planners and accountants would be able to give a more accurate number on their experience. But usually, like if the inheritance is just going to be tipped straight into a beneficiary's mortgage, and like maybe they'll upgrade their car and go on a nice holiday or something, and there won't be a lot left, then probably there is no point in paying for the extra tax return and administration compliance of the testamentary trust. But especially if there are minors who can access accepted trust income treatment for several years and maybe double dip once the next generation has come through, and or there's asset protection advantages, then usually 500,000 or so is about right. And some people go, well, I'm not getting any accepted trust income, but I'm in a high risk occupation and asset protection is important. Others won't care about asset protection and they just want the tax. So I say 500,000, but there's no science behind that number, no formula.
No, I think you're right, Tara, too. It's really about the beneficiary at the end and what's going on for them. So, like I was thinking about, well, $200,000. It doesn't sound a lot when you talk about the numbers that sometimes we deal with in the financial industry, but $200,000 is still a lot of money. And if you've got a kid at 18, that just really is terrible with money. Okay, shops too much for earrings that look like cats, maybe. I think that can still be worth protecting. And there are other ways too, just because they might want to use it to buy a house, giving them the money and winding up the trust is not the only option, provided you have the ability within the trustee to do it, that way. You can loan the money from the trust so that acts as another loan should that person go through bankruptcy or relationship breakdown, those sorts of things. So I think the decision about when to wind up really is about weighing up those different pros and cons and working out what's the right thing for the people that the trust is supposed to benefit. So that's sort of the summary I've done for today. I sort of keep it nice and sweet, but certainly I'm happy to have a discussion. I'm happy for people to disagree with me as well. I love finding out that I'm wrong about things because it makes me get excited and go down legal rabbit holes. In terms of the concept here with estate administration, again, is that this is very front-end stuff. I don't have a lot of knowledge about the really messy back-end stuff. So when it comes to those ongoing issues with trusts, that might be something that has to play in with that as well. Okay.
Thank you so much, Carrie. And I accidentally booted your slides off when I tried to share my screen. Are you finished with what you were sharing?
Yeah, I am. Yes, I am. Sorry, my dear.
No, I thought I could do it sneakily in the background, but didn't work. So that is so insightful and detailed. Thank you for putting together such a comprehensive presentation. There's a few things I just wanted to mention. So firstly, I've got together this one pager. If you do want something just to have in your notes so you can refer back to or send to a client or something. So I'll share the link on how you can download that so everyone can get it. And I just want to elaborate on steps 5 and step 7, because you did touch on them, but I've had a few people in the Art of Estate Planning course ask me quite detailed questions about this, and I wanted to sort of share with you guys what I've shared with them. So one of the questions is kind of pinpoint, when does this mystical testamentary trust start? When do I need to worry about all this stuff, and how does it start? Does the will start it? So I think what helps me in my mind is getting back to basics and almost drawing on a piece of paper, where are the assets? They were with the deceased. Then we moved them to the legal personal representative. And to do that, we had to make notifications to the banks. We had to transfer any properties, transfer shares, that kind of thing. And now to get them out of the legal personal representative into the testamentary trust, it's almost as if we were transferring them into a family trust. It's the same type of thing. It's almost like an asset sale, right? We need all of the forms, the titles office forms, the Office of State Revenue forms, the computer share forms, the ASIC forms, as Carrie, Carrie, you went through all of this before, but you literally have to record methodically the transfer from of every single asset into the testamentary trust. And then you need your deceased estate resolutions to record all of that. So the trust, I think, when you pinpoint when does it commence? Well, it commences when the testator dies, but it has nothing in it. It just has a right to receive the assets on due administration of the trust. The assets get in there by the executor after the estate being finalised, actually sitting down and transferring the assets in and recording that in a resolution. So I just wanted to make that clear, because I think, one of the accountants saying, well, how did the assets get in there? And I'm saying, well, the lawyer would probably give you the transfers, but they didn't have a lawyer in this case. They were sort of managing the administration on their own. And so I think that's where the disconnect was. And I've had a few people sort of say, oh, well, yeah, it's a little bit like, it seems a little bit mystical. But if you take it all back to core principles of different legal entities and how do you get things in and out, it's just the same as assets that get transferred during a person's life.
Yeah, I say that often, the time that a testamentary discretionary trust is just a fancy normal discretionary trust that you only get when someone dies. So the same thing, if you want to transfer a property to belong by a family trust, you have to buy the property and do the transfer forms over. So it's the same thing.
Yeah. And then there's step 7 about recording the source of the assets. So this is tied into the ongoing tax treatment. And this is for the accountants, really, because, as you know, they changed the accepted trust income treatment rules midway through last year. I think I'm actually losing track. I think it was like, we did a live on it like at the end of last year. I think it was midway through last year, where the source of the assets in the trust really matters. And it has to be, the assets in the trust have to be from the particular deceased. And then there's a whole lot of rules about, reinvestment of assets and contribution of new assets. So a new thing, this is brand new. So if you don't know about it, no one knows about it. We're kind of making it up as we go. A new requirement is that for audit purposes, when you claim your accepted trust income, you probably need very detailed records of where did all of the assets come from. So I'd be adding an asset register for ongoing compliance into the process as well.
Yeah, no, it is really important. I think, Tara, even too, for things like superannuation, if your superannuation comes over into your testamentary trust and you have sub-trust provisions where you can put that aside, again, it's recording it is all where you can actually prove that. Again, you can use separate bank accounts as a bit of a strategy to keep those assets separate, but it is all in the writing.
Oh, that's a great point with the superannuation proceeds. Yes. Exactly. You need to be making those resolutions at step 5 to set up the additional sub-trust for the narrower beneficiaries. And I love the bank account idea. It just makes it so much easier.
Yeah.
So we've talked about a few different concepts: super proceeds trust, estate proceeds trust, diving into the difference between testamentary discretionary trusts and bare trusts and how they're all testamentary trusts. So the trainings we've done on those separate topics are all under the guides section in the group. If you're new to the group, there's a guides section where every Facebook Live has been saved under different topics. It used to be called learning modules. If you're looking for that, it's now called guides. And you can go back and watch those. And I'll also just say, because we are coming up to the end of the CPD year, at least for lawyers, you can get CPD points for watching these. So you should be fine to self-assess 1 CPD point per hour. So record your CPD points, don't forget. And I'll also just let everybody know, if you are wanting to further your mastery or practical resources relating to testamentary trusts, be aware that we've got the Testamentary Trust Starter Pack, which is a marketing resource and an education resource for you and your team. So it has a 1-hour free training on testamentary trust, really diving into sort of the detail of them and some of the strategy decisions, as well as marketing resources like newsletter templates, flyer templates, and a video that you can send to your clients explaining them. So if you want to hit the ground running with testamentary trust, that's a really good resource. And for the lawyers watching, we also have the Testamentary Trust Precedents available. So if you believe in the value of testamentary trusts, but you're lacking confidence around drafting them or preparing them, or you just have some doubts about your precedent, you can watch a video of me stepping you through my precedents that are available to get a feel for them, work out if they're going to be the right fit for you and your client, and if you like working with them. And that's all. If you go to the Art of Estate Planning website, taraluke.com.au, that's all there. Now, we've got a few more minutes before we finish up. If there are any questions, now's the time. Thank you, everybody, for taking the time out of your day to join us live and for sending the feedback. I'm so grateful. And if you're watching after us being live, you are also very welcome to put your comments into, and Carrie and I will keep an eye on the comments and try and answer any questions as they come through after the fact. Now, I'm checking, I can't see any more questions, so we might finish up then. I'm going to go have my lunch. Carrie, thank you so much.
No, that's okay. I'll provide that link now. I've got my Facebook open ready to go for the TFN stuff. It is actually, if you've not done it, just to go on there, it's not hard to go and do a practice run. You're not doing anything until you hit the final submit. So get on and have a bit of a play around with it.
Carrie, on behalf of everybody, thank you so much for your sharing your insights and your very comprehensive presentation today. Bye, everybody.
See you later.